Welcome everyone to the 2020 CELS Forum in Ethics, Law, and Society series. We're really excited today to begin our series for the fall. This is our first time on Zoom, and welcome you all. I see a bunch of you streaming in at this moment, and hopefully everything will go well. I would like to ask you to bear with us if there are technical difficulties, which there almost always are on Zoom. You might see lag or anything like that. If for some reason the stream cuts out, we will restart. So just please log back in if that happens. It won't, but you never know what's going to happen. So really excited today to have Sam J with us. He is from the district's attorney well, where are you from, Sam? You're in Santa Fe, correct? And New Mexico.
Albuquerque.
Albuquerque. Okay. So he's going to speak to us on feminist issues, and we just had a great discussion with him before the talk, and I hope that we can get some of the some discussion about how courts and everything is changing here in light of COVID. So I'm going to let Sam take it over from here, and then I will handle question and answers. If you have questions, please type them into the Q&A, and I will be monitoring that, and then Sam will be answering those. All right, so thank you very much. Take it away, Sam.
All right, thank you. All right, so my name is Samuel J. I'm a public defender out of Albuquerque, New Mexico. I work in the Metro Division in Albuquerque, so that's just commonly referred to as like poverty court. It handles all misdemeanor crimes. So no serious violence offenses yet. This is just like crimes of poverty, which are fairly easy to defend because morally you're just like, stop arresting poor people, please. Please ask questions. I'm looking at the Zoom chat, and your teacher will also moderate them. But please ask questions. This is going to be helping kind of some chat. What I plan to do is just over the general course of a case from arrest to plea to probation. I went to University of Oregon, and I got a double major in women, gender studies, and sociology. So how this all arose is I contacted Professor Megan Burke. She taught me back at University of Oregon. I like to contact her often about questions I have that arise out of my work. And so I'll go through from like arrest through the end of a case with like the issues I see. And I don't know if I have any answers, but I would love your input. If someone's how to do this better, I would love it. If it brings me a new idea, I would very much appreciate it. But that's what I plan to go through. Okay. So kind of University of Oregon, and then I went to law school in DC and found public defense there. So like right off the bat, I wanted to go to law school to help people. Someone once called it like being a superhero, and I thought that was a little dramatic, but you get to actually stand in front of a bad situation and help somebody. I wanted to be a prosecutor to prosecute like sex crimes, represent alleged victims or victims who had suffered something, and for me to, prosecute bad people. And it's a law school, as prosecutors have no discretion. They have no power to help. They have guidelines. They have to just eat the party line, as many people in jail as they can, and they're political actors, so they're subject to political being tough on crime, going with the standard offers, not being empathetic, not, being a human. Just you're pumping out pleas, and you're just putting poor people in jail. So I found defense work, or public defense. And it was a quick, easy way to do it. Patriarchy, systemic oppression. Had read all these brilliant minds of people of color, and it was real fast and real easy to be like, oh, the state's the biggest oppressor of them all. to help out. And this during the time of, Black Lives Matter. I was in law school when Philando Castile, shot and he murdered, and I was there for so many things. So public defense is real quick, jump and easy. All right. So how a case gets to me. There's an arrest, and already you have a ton of like gender issues and intersectional issues in an arrest. Like, it's a domestic violence for me. If it's a domestic violence case for me, there's no serious bodily harm. There's just a fight. In Albuquerque, typically, no one really believes that a woman can batter a man. A cisgender woman can batter a cisgender man. That's not right or wrong. Like, obviously we have problems there, but as soon as I get the arrest, you can look and all of a sudden it's like, oh, the alleged victim in this case called the cops. Cops came, saw that the alleged victim was a dude or a guy, and they arrested him for his own alleged battery, which is obviously problematic. He called the cops for help. They arrested him because they got there. There was a fight. They arrested the man. The woman who is, accusing him of hitting her gets off scot-free, and she now knows this. And we'll get into how bad that can be. But sorry, you have gender dynamics. Then for DWI cases, a lot of cops like to pull over young, attractive women. I get a lot of cases where cops like to haunt certain areas where they know kids will go a little too fast coming back to the college area, and they pull over young women a lot. There's also, you can read in the arrest certain weird factors. It's like, why did this cop do this? So yeah, that's the arrest. Now, if any of you don't know, what happens after the arrest is an arraignment. So there's two kinds of arraignments. It can be a bond arraignment, which is just you show up to court on your own volition, and the judge reads you the charges, possible penalties. You enter a plea of not guilty, and then he'll decide conditions of your release. A custody arraignment is you are in jail already. They arrested you at the scene of the arrest, or at the scene of the crime, alleged crime. They put you in jail, and now you're in an orange jumpsuit sitting in a room with about 100 other people, and there's just me sitting at a podium, and a judge is on a computer monitor a couple, like 30 miles away at court, because jail here is 30 miles away to court. So at arraignment, we like to bring probable cause challenges off just the four corners of the complaint. And so what I struggle with, or what I would like your input about, is that if an officer forgets to put relevant information, legally relevant information on the criminal complaint, I move as a defense attorney to dismiss, or based on probable cause, move to dismiss a certain charge, right? Typically happens with domestic violence cases because a householder is a certain legal definition, right? Like, so if you live with your cousin, that's it gets a little tricky. Like, household member is spouse, girlfriend, ex-girlfriend, or like your mom and dad, household member, mom and dad. And then it gets more complicated for like sister, brother, no, might be messing that up, but if they don't put the right information. So what if they just happen to say, like, this person called me, I went in, I saw a fight had definitely ensued, like red cheek, definitely consistent with a hit, and he only lists her name. And, only lists the name, Jane Smith, reddish on cheek, said a fight had broken out. Defendant, John Doe, yeah, I totally hit her. Living together, kids in there, whatever. All signs point to they're definitely a household member. My job as a public defender, or his job, is to do the best interest of their client. I move to dismiss or bring a probable cause challenge saying that doesn't qualify as a household member. And already I got them 6 months less jurisdiction or possible jail time, being that, like, yeah, this could be like a horrible history of abuse. Yeah, this could be a serious domestic violence situation. However, I'm going to get my client off, and I know I'm going to do it, and I can. So as a feminist, or someone who tries, who, studied women and gender studies, who wrote, whole papers on, the power and control wheel of, abuse, of how underreported sexual is, or underreported, all abuse is, or gender, sexualized violence, gender, whatever. That's already like, well, does that just disqualify me from ever being, I'm definitely being participatory in a system of oppression, right? Like, I got an alleged abuser, better deal already. So still at arraignment. Now we try to talk about conditions of release. So if you don't know, you get an arraignment, read you the charges, possible penalties, and the judge goes through your criminal history and says, all right, I think you're a flight risk. Like, you've got hundreds of bench warrants. I'm going to keep you in jail pending your trial. Horrible. Or judge thinks like, oh, you have no history at all, I'll let you out. And already, like, there's no guidelines to that. It's just a judge's perception. There are some, like, there's constitutional amendments and there's case law to be like, hey, you must consider other means of conditions of release are not just putting someone in jail. But besides that, judges, at least in Metro Court in general, like in lower courts, they'll just use their own discretion. That's terrifying. Judges will just be like, oh, no guidelines in domestic violence case. I'm sorry, I'm seeing a question. No guidelines to domestic violence cases, punishments. We're just talking about conditions of release. I can talk about that a little bit later. Just conditions of release. Yeah, no, not in practice. There might be some better ones out there in Albuquerque right now. We're just going, judges are just going like, read the criminal complaint, which is facts, not in evidence, so problematic. And they just go like, F it, I'll let you out. Or, oh, like I have been in front of judges who just love, like, they love women. Like, women can do whatever they want, fuck up conditions of release, and the judge is just gonna be like, no, I'll let you go. You can stay, you don't have to do more. Men of color, men who work construction who come to court a little bit dirtier because they got off a job site, Black men, or guys with accents. Like, I have a few Cuban clients who have like a really big boisterous voice. When they talk in court, when they show up to court, they're treated like shit, or they're treated worse. And like, all of a sudden there's like zero tolerance. All of a sudden their conditions are super hard. And the thing I struggle with is like, if I got like a pretty woman client, then I know like, oh shit, like, this is easy case. Like, I know I can get her all the excuses in the world. And like, my Cuban client got put in jail for like a month and a half because he was agreeing with the court just too boisterously, and it was offensive to the court. So, all right, I'm looking at questions. Hold on. That was most difficult. Okay, these are a lot of really good questions. And okay, I'm just looking at the last one. And yes, hundreds of people have been falsely accused. Like, I represent tons of people who have been falsely accused. And we're gonna get into that. Like, again, I love these questions. I'm gonna keep looking at them. We're just moving one at a time. We're just at arraignment and the long case. Okay, so that's at arraignment. The problems that I at least see, like an intersectional problem where like feminism, gender dynamics, systems of oppression coincide at this point in the case. Conditions of release, that people of color, especially male people of color, are being treated worse than women. However, it's so discretionary. Like, I have some women who like, I don't know, kind of DWI for smoking pot, and the judge just like really dislikes pot, and he's like, all right, like, you do that, like, okay, you did this horrible thing. In his mind, again, facts not in evidence, just reading the police report because he has access to it, and he goes like, conditions, and he puts her on like pretrial supervision, which is like probation before you've actually been to court, and you like drug testing, checking in, maybe GPS monitor, maybe an ankle bracelet that detects alcohol, which is all money that people can't afford. And as soon as they violate, he's like, going in jail, you're done. you get no more chances. And so as the problems we see it, the conditions of release. What is the most difficult? Oh my gosh, we're not going to go there yet. Okay, these questions are really great though. Please sending them in. Okay, so that's at bond arraignment. All right, now pending trial, and trials in this poverty court, metro court, they have a limit. Has to be 6 months, or we call it the 182-day rule, from the day you're arraigned to the day the trial starts. 182 days. Little flexibility with defense versus state. Continuing or moving things up, basically 6 months. And I tell people settle in for 6 months. Pending that, so they're on conditions, okay, of release, right? And they have to be doing drug testing or checking it. And then we start doing like pretrial motions. So what gets really complicated and what we start looking at is like, let's say someone violated a pretrial condition. The Victims' Right Act says like a person can, like an alleged victim can speak, alleged victim can speak at a conditions of release hearing. That gets terrifying for a public defender because an alleged victim will go in there and spew their entire life story and the history of abuse they faced, right, or like true or untrue, and will go off. And as a public defender, I bring up the Victims' Rights Act and be like, actually, they're not allowed to talk. They can't talk about like the case right now. Like they're talking about the case. You can't, they're going too far. Like, how dare they speak this? And it's your job as a public defender to zealously advocate for your client. That's Gideon versus Wainwright. That's the Supreme Court case. Like I have to do that. And what I struggle with a lot, especially coming from a women and gender studies background, is that so many of the alleged victims that I go against are lying, and that doesn't really reconcile with what I know and what I've learned, and I've caught them in lies. Let me see, I'm just checking the chat. Ooh, I like this question. How do you feel about representing those that are guilty but having to defend their case on an innocence plea? Okay, so not guilty is not innocent. So maybe that's a too lawyerly of an answer. Saying I'm not guilty of something is not saying I'm innocent of something. So there's already a distinction there. But a lot of people I represent, are guilty. I am in poverty court or metro court, so there's no serious violent offenses yet. Very soon be moving to felony, hopefully, knock on wood, where I will be representing more serious crimes. As far as these crimes, I don't have too many qualms with it, and that's part of the problem. I'm wondering why. Maybe I should have more, and this is part of the reason I'm having this discussion with you all. But for the people who are guilty, let's say they are super effing guilty, my biggest motivation is holding the state to higher standard. The state, if they learn they can cut corners, and if they learn that we are not going to fight them every inch, tooth and nail, they learn that they can get away with stuff, they will abuse discretion. It's been proven over and over. People, they have all the power. And with cops, like I get to have cops on the stand, and I get to cross-examine them, and I basically get to prove to them, or at least say an argument leading them to be like, me saying like, you're effing stupid. Like you did shitty police work. You do not deserve this. And like my client is innocent because you didn't do your job. So as far as guilty people, that's at least my biggest motivation off the top of my head when you asked, is that I think holding the state to a higher standard is, well, it's the hallmark of this system. It's an adversarial system for a reason. It has to be. Where was I? Oh, pretrial motions. So then the gender dynamics at a conditions of release hearing with an alleged victim who's there, who's spouting off everything under the sun she can think of about how horrible this human is that I represent. And it's my job to be like, under the Victims' Rights Act, she is allowed to speak here. She's not mandatory, and she certainly can't talk about the merits of the case. And right now, it's just being massively prejudicial. And there's all these rules. Okay. All right. Okay, sorry. Well, all right. Okay, so just looking at questions. Okay. So pre-trial motions, conditions of release hearings, and then you start also getting in the gender dynamics of. Okay, I'm seeing Megan Burke's question. Hey, can I say more about keeping accused out of jail is actually a feminist commitment? You haven't explicitly said that later, but it's implied. Oh, okay. Well, I hope it's a feminist commitment. God. Okay. So question is, can you say more about keeping accused out of jail? Jail is actually a feminist commitment. So one, I mean, obviously tons of women are in jail, and when I get to talk to them about why, it's a lot of different reasons, but everyone's innocent until proven guilty, and I feel like people always forget that. They're innocent. I don't give a shit. Like, they're innocent. Why are they in jail? They're innocent. No, like, it's a huge cost to state to keep people in jail. It's horribly prejudicial to keep someone in jail. People in jail who, experience, like, I think it's 3-week increments, like for every 3 weeks or every week, like, their case is worse. Like, they'll plead out easier. They'll lose the fight. They'll accept a worse plea. Like, keeping people in jail is horrible. And I don't know, the state's the biggest oppressor of them all. Like, why do you, like, how prosecutors file preventative detention motions, or how prosecutors say, like, I want this person to stay in jail, is their own discretion. And they have some guidelines, like, X number of convictions, X number of accused, X number of dismissed cases that are still, or depending cases. That's still up to that's still them reading into it, and they bring their own biases to it. And there is a gender bias there. Like, women shouldn't commit certain crimes according to whoever is deciding to ask for revocation of conditions. Like, or biggest that I try get, the biggest way I see gendered implicated in revoking someone's conditions pre-trial or post, is a probation officer got offended my clients for whatever reason, and there's usually a gender component, right? Female probation officers will be like, that guy's a fucking dick, super disrespectful to me, horrible person, says all this shit, blah blah blah. And it will creep in. They do bring up a gender component. Now, I'm not saying they were wrong, probably is. However, how that probation officer takes that interaction and then says this person should be in jail for whatever time has a gender aspect. And especially with women, and right or wrong, and I could be offensive, and I'm sorry, but with women probation officers dealing with women clients or women defendants, they are so fucking judgmental. They have no empathy. They will revoke them on the fastest they can. And I'm really sorry, like, I'm getting heated. I hate probation officers. I don't know, like, a probation officer basically is an ATM that spits out, like, jail sentences, like revoke, jail, which means revoke their conditions, put them in jail. It's just like jail. Like, I don't know why I talk to you. And yeah, so that's, I don't know if that answers Megan's question. I think I'll get around to it eventually, but I'm looking at more questions. But that's probation officers, and, like, that's usually the biggest gender problem I see, is a probation officer who does work pre-trial supervision and obviously probation will take offense or be offended by something a defendant does, and there is always a gender component. I don't know. And then we'll get to specialty courts, and that'll bring this back up again at the end, towards the end. Do I ever face judgment as a white-looking man who majored in women's studies, now representing minorities? I guess. Don't really care. The biggest thing I get when I say I majored in women and gender studies is that, was I trying to pick up chicks? And no, I wasn't. And yeah, anyway, that's the biggest judgment. If you're gonna go with judgments, is everyone was wondering if I was looking for a date, which is weird, but yeah. Anyway, so I'm going to answer this question, the bias question, as we keep moving here. Okay, so that's pretrial motions, kind of like pretrial, like conditions of release are still a thing. There's a lot of pretrial motions we do, a little bit different, but I'll move forward. Okay. We'll start the trial. Okay. So trial. If it's a jury trial, there's a lot of things to consider. We're going to start with jury trials because they're the hard and most complicated. We'll go down to bench trials, which is judge only, pretty soon. But a jury trial, you start with a voir dire. What that means is you get here like 27 potential jurors, and they sit in the pews, and each side, state and public defense, gets about 15 to 20 minutes. It's a little different now, to voir dire them. What that means is you want to get to know your jurors so you can pick the best out of them for your particular case, right? You're entitled to a jury of your peers and a cross section of the community you live in. So if we're talking about like gender and different, intersections I see, if I have a client who's a woman accused of domestic violence, let's say on her husband, then I'm going probably to be pretty, like, I'm looking for guys, like big dudes who, like, Trump supporters, no offense to anybody, but Trump supporters, conservative Republicans, like people who don't believe in domestic violence and sure as shit don't believe that a woman could be domestically violent to, or commit domestic violence to a man. So I'm looking for. Same thing with like DWIs. When it's a low breath score, when it's a low alcohol content, someone, I'm looking for people who like drink. Like I'm looking for, people who go out, drink, drive home, no big deal, who have a few beers and they just don't believe in drunk driving. And a lot of times that happens to be also like conservative men. Now it changes obviously very quickly when you have like, well, you have like a guy accused of domestic violence of a female, and then you're looking for jurors. You're trying to get a whole man again, or you're looking for you're just looking for the weirdest people. One of our best jurors who looked the best was like female, veteran, hugely conservative, and kind of said something to the effect of like, "I'd never let a man hit me. So if someone else like if someone hit a woman, then she was asking for it." Not that explicit, but it was close, and we were like, "That's who we want on the jury." So again, this is all like, well, what am I being participatory in, or what am I like? I'm being massively sexist, like, and that's the charge. Like, I need a jury who's going to understand and return a not guilty. A lot of questions rolling in. Do you find a trend that non-white minority female clients face heavier charges than Caucasian females would? Well, most all of my clients are like women of color. Face harder charges. Charging is a weird thing on itself. I don't know if you mean, because it gets conflated, like charging, or like the charge a cop thinks it is, and he like writes on his police report like aggravated battery, or the sentencing. That's a whole thing. And again, discretionary, because sentencing's up to the judge. So I have a few judges I know who will like convict you in a heartbeat. Like they're going to convict anybody. They're going to convict you. However, they're going to give you like a really great sentence. Now, there's a lot of collateral consequences to a conviction, but that's the way a few judges like to split the baby of like, you're definitely guilty. I don't care. You're going to be guilty, but I'm going to be so nice on this sentence, I probably won't get appealed because like this sentence is so easy. Like they're given like small probationary periods, no conditions, easy money. Okay, so voir dire. You're trying to get to know the jury. You're trying to get to know how they think, not so much their opinions, but how they think. Is that what you're trying to do? So yeah, a lot of gender dynamics. We like, you know, for African American, you know, defendants and our clients, we need people of color on the jury. We just freaking need them. Like any people of color, you need them on the jury. You get really scared if you're getting like a lot of like heteronormative cisgendered white guys. You're getting kind of worried. Um, and then again, all the responses are so subjective, and they all have like weird ways of thinking about things. And a lot of times what we'll do, especially with domestic violence cases, be like, who has experience with domestic violence? Either a friend, family, whatever. People raise their hand. And then you ask them about it. And then things come out, people start interacting. And like, do you want someone who has domestic violence experience either being accused? Because if you get someone who's been through the system, who, you know, was on probation or did get convicted of domestic violence, like, I want that guy on the jury. Like, I want him there. However, a state's probably going to strike him for cause or strike him as a preliminary. But yeah. So anyway, blood ear. It's really interesting. There's a lot of science about it and how to pick a jury. There's a lot of science to say it's meaningless, but there's a lot of science that's like, how do you do this? Like, how do you get it right? All right. So moving on. So you've picked your jury. You've whittled down. I won't get into how, but you've whittled down to 7 here in Metro Court 7. Now you're gonna like do your opening, and we'll just go through the merits of the case. But it's all, again, a thing of, are you trying to paint this as, and a lot of times I win with this, of like, this is like kind of like a, you know, a sexist cop who's like hitting on a DWI defendant who like just saw like a pretty girl driving home at night, and he pulled her over to whatever the hell, like harass her or get some kind of like jollies out of it. And she does DWI, like all the fields for DWI test. He still charges her. And we're here now. So I got to paint this as like, okay, this is like a predatory state taking this too far. This is a bad investigation because this guy was just thinking about how hot she is. And, you know, it's a sloppy investigation because he had no actual evidence to do this, but here we are, and he's wasting your time as a jury doing this to someone. Other things, domestic violence cases get kind of really story specific. There was a good case we did where that wasn't me, it was our office did, where it was like this guy had like beaten the shit out of his girlfriend's kids. Sounds bad, horrible. Oh my God, no one's here to defend him. Came out because our first question, or my coworker's first question out of the gate to the alleged victim was, how old are your kids? She's like, 18, 22, 24, and 26. Okay, what? Like, and then it just like came out in trial. Like, DA had painted a story of like, this asshole beat the shit out of this woman's kids. Came out, kids are all like 18 to 26, freaking like athletes who, during an argument, our client with the mom, during an argument, just beat the shit out of our client with like with like stuff, and our client got like, police get there and just see our client defending himself. Okay. Okay, this is a good question. Oh God, these are good questions. Okay, do you think, based on all these mistakes that happen very often in cases, that would it be different if people understood more of their rights, that maybe results could be different? No. No, because where people need to understand their rights is like, well, it's like, the cop pulls you over. All right, they have reasonable suspicion to pull you over, let's say for traffic. Reasonable suspicion, that's a very short custodial interrogation, very short. If they prolong it, they have to develop reasonable suspicion for another crime. So during those interactions, states are different. You have to identify yourself here. Some places you don't. Some places, like here, you have to get out of the car if the cop tells you and give him an ID. Some places you don't. Well, actually, that might be I think that was a Supreme Court case. I think you might have to get out of the car. If a cop tells you to get out of the car, you might have to get a car. But don't quote me on that. Anyway, that's where you need to know your rights. Is like, is this reasonable suspicion? Like, is this a custodial interrogation for the purposes of reasonable suspicion? Or is this just a voluntary interaction? If a cop walks up to you in the street and goes like, what's your name? You can respond with like, Did I commit a crime? Like, are you investigating me for a crime? And the cop kind of has to say, like, yeah, I think that was jaywalking. Then he may have constitutionally reasonable suspicion to stop you for a brief moment to develop probable cause to arrest you or cite you for a crime. So that's like where it's like really tricky. Like interacting with police officers is very important. Like, are you in your house? You need a warrant to enter your house, unless like, I don't know, there's exigent circumstances. There's a whole different doctrine. That's like where people need to know their rights. Like, is this a voluntary interaction? Am I actively giving the cop more information, or are they legally like required? Like, am I legally required to give more information? Different for different states. So that's where people really need to know their. Dante Leonardo, can you rewrite your question? Because that's interesting, but I'm not sure I understand it. Okay, how are you able to defend and justify abuse in any sense? Does that take a toll on you? Yeah, but okay, as far as how, again, there's just a couple. I sent Megan Burke a great article about what motivates public defenders. It's like a very eloquent BuzzFeed article, like which public defender are you in this, and it gives like 13 different examples. Like I said, holding the state to a higher standard and making sure the system works as crappily as it does, but at least works, is a huge motivation. And as far as taking a toll, like, yeah, it does. I talk to Megan Burke a lot. Like, I ask her questions. Because your job is to zealously defend your client no matter what. You have to do this. It is your charge, and the whole system crumbles if one side gets lazy. Like, if public defenders get lazy, then we sell people short. We abuse people's rights, right? Like, if I just push pleas on everybody that I thought was guilty, then I'm a cop. I might as well just be a district attorney. The district attorney gets lazy, then they let every wrong go by. There are wrongs, but like, I only know that justice is done if I am going as hard as humanly possible against the state at every turn. That's how I ensure justice is served. I cannot let them go by even an inch. That's the whole charge. Okay, this is a good question. I thought that jurors were dismissed if they experienced something similar to the case being presented because there's possibly a biased vote. Do you mind elaborating on that process? Yes, absolutely. Okay, cool. So jurors are dismissed. You have to develop a good cause, or they're dismissed just as a preliminary. Like, a lot of states have different ways of doing it. You get a preliminary strike. It's usually just two. You can strike anyone from a jury as a defense counsel or district attorney for whatever reason you want. You get two. Now you got 7 chairs to fill, and you got 27 people to choose from. So you get 2 each side, and then you need cause, like 4 cause challenges. Now, if I have someone who has experienced domestic violence, and let's say I really want them off the jury because they go like, yeah, I have experienced domestic violence. I need to go and tell me about it. And they say like, I was a victim, or they say I was accused. Very different. Let's say they say like, I was a victim, and they go, and we're like, okay, so how does that make you? Like, how does that affect you? And like, well, I have PTSD. Okay, probably like, I don't need to go more, but the state will be like, is that going to weigh on your mind throughout this case? Yes. Like, or I would say that, like, is that going to weigh on your mind throughout this case? Yes. Be like, and that probably affect how you think about this case? Yes. I would move for cause, saying that person's going to be like triggered by this. They're going to have a visceral response. They're not going to be able to judge this fairly and impartially. District attorney is going to want them on the case because they want people to convict. So they're going to want that person to stay as a juror because that person's going to be like, yo, fuck that guy. Like, I'm putting that, he's guilty. I don't care. So that's how it happens. Now, to rehabilitate that, the district attorney, all they have to say is like, can you be fair and impartial? And everyone's going to say they're going to be fair. Like, who's going to say like, no, I'm not going to be fair and impartial? So, ooh, wow, 15 minutes left. Oh gosh. And there is a question and answer after this. Okay, so, okay, oh god, juries. Okay, so, okay, damn. Okay, there's so many good questions. So, in the trial, we see that I like struggle with, you know, you have to, as a defense attorney, look at an alleged victim, which is already, like I say alleged because they are, but I look at someone who has experienced something and I have to cross-examine them and be brutal, right? I have, like, you have to be like, well, you said you saw him. You said this is a violation of restraining order. You said you saw him there, but he wasn't there when the police got there. You took 40 minutes to call the police. Yeah. You had a phone on you. You didn't videotape anything. No, you knew he was going to be there. You still went. And I have to, like, as hard as I can, like, rip him a new one. Now, in total opposition to what I've learned, most alleged victims I've gone against are lying. And I don't really know how to deal with that. I've had a few cases recently, and I had a call Megan Burke about this. I had a few cases recently where the alleged victim in one of my restraining order cases just keeps fucking filing new charges, and my client's never on the scene. There's no video of him. There's no damaged property. There's no trace of him, and he just gets a summons for court later. And I had to cross-examine her on like 4 alleged violations, and she's just lying. She's super sympathetic, small little thing, pretty. She was lying. And then after I cross-examined her, like, I ripped her a new one, and I won the hearing I was there for, she filed another case. And the best part was, because of all the problems, the judge had put my client on a GPS ankle monitor so he could go from home to his work to home, nothing else. And she alleged that the next day, like, he's got the ankle monitor for, like, a while. And she alleges next day he goes to her house, damn near breaks down the door, saying all these crazy things. And the cops get there. He's not there. Neighbor says, oh yeah, I saw him. He was there. She says, oh yeah, I heard him. He was there. He's got an ankle monitor on. Probation officer even's like, no violation. He's not even there. He's across town. And she's got like 5 or 6 restraining order violations on the guy. We pled him a year ago because she was going to sink him at trial. And she's got 4 or 5 new cases on him. And like, like, the woman in gender studies major in me is like, oh, this is a system of abuse leading to someone dying. The power and control wheel of, like, asserting dominance, control, isolation, jealousy, fear. Like, this is probably what's happening. But I know my client and I know the evidence, and my job is to zealously advocate for him. And I realized, like, she's freaking lying. And we had proof. And yet she's still filing false reports, and he's eventually going to do jail because he is on probation for 1 charge that we pled him to, not because of anything, but it was a good plea deal, way too many charges. It wrapped like 3 years of jail time into like 6 months of probation. But anyway, that's a huge deal. Okay. So yeah, through cross-exam is the most personal and, like, vicious thing you can do to someone, like alleged victim, cop, whatever. Okay. Sentencing. Well, can someone give me a time, how much time I got left? But the biggest thing also, and I know some of you are like pre-law, considering law, if you go into public defense, the standard test of a public defender at an interview, thank you, at the standard test for a public defender at an interview is you get a set of facts. It's a story of an alleged, and I'm sorry if anyone needs to leave or mute for a while. This is about sexualized violence. Standard thing is to do a cross-examination of a rape victim, and you get like a set of facts. Nothing really gory, just kind of like a down the middle 50-50 of was this consensual or not. You go with a consent defense, and you have to show to a room full of public defenders the questions and the way you would cross-examine someone who was raped. And yeah, and so it's brutal. It's you do that for all these different public defender offices, and they need to see it. They need to, if you have any reticence about doing that, if you have any hesitation, if you have any moral issues, they will not hire you. And honestly, you shouldn't do the work, because the only thing keeping you going in this job is just you being able to feel like you are doing something in the world that's good, and for whatever reason. But yeah, that's the standard practice: is cross-examine a rape victim, use every little detail of the fact pattern. Like my fact pattern was like, my cross-exam was horrible, but I did it well. My cross-exam was like, my cross-exam was like, well, you opened the door for him. You had texted him this day. You took off your jacket and laid it down on the ground. You never said no, and all this horrible stuff that I've studied and read about, and my classmates have even said in testimonials. And I did it, and I will do it when it's real in a felony level, but it obviously presents some moral dilemmas that I'm sure people have questions about soon. But okay, so trial, basically cross-exam is the public defender's bread and butter. And then closing arguments are huge. I'm going to read a question. Hold on. This is a good question. It's not about gender, but do you as public defenders actually have enough time and resources to address every single client efficiently? There's a common problem where there are too many cases. Yeah, so here we do. We have pretty big staff. It's still fast and loose, which is rough. However, the charges I face and the charges each court faces are kind of the same. So you kind of have an idea of the defenses that are available to you, the discovery issues that you usually face, and the typical way things go. So like most of my cases are DWI, domestic violence, and then general criminal matters, which is everything from like shoplifting, larceny, criminal damage, restraining orders, domestic violence, and all that kind of stuff. You kind of have an idea after a while what you're going to do. It's just time management, but it's pretty okay here. Like New Orleans full shutdown for a while. That's the big story if you want to Google it. Okay. Oh God, that's a good question. Have you ever been unsure the details of a case? If something that seems like potential moral issue is dubious on detail, how do you orient yourself? Oh, well, that's the whole, you could do it a lot of ways. It's so dependent on a case. So some clients, I just know their life. Like I just know them, and I'm like, no one should do this to a human. Like no one, like the criminal justice system destroys lives. Like no one should be punished this way. No one should do jail for that. Like for this person, like yeah, they did something awful or whatever, but they have a family. They're a good dad. They have good this. They have good that. Like they shouldn't have to face this kind of punishment. And a lot of times, district attorneys don't have the discretion to give me a good plea, like a plea offer that's like, I take it. So I have to go to trial, and they have to face the full judgment sentence. So in that way, like I just know my client. I don't want this to happen to anybody, and I'm trying to stop it. Other things is like holding the state to a higher standard. Other things is just, vanity, or not vanity, but ego. There's an egotism thing of like, I just want to win. Like I just want to fight. Sometimes I just hate my district attorney, and like I need to put them in their place. It's better for everyone in the long run if the district attorney knows not to fuck with me. Okay, 5 minutes. Oh, okay, so we're at cross-exam. The closing, that's the whole, like you get to now argue. Opening statement, you can only to be like, tell the jury like, what you'll see in this case is that this was a mutual fight, or what you see in this case is that yes, she had a drink, but it's not illegal to drink and drive. It's illegal to be under the influence. And now we enter, whatever. Closing arguments is an argument. You use a fact, and then you argue why it's important. So you just go, in the horrible rape case, the idea, it's like she put her own jacket on the ground. And that tells you that she meant to do this. It tells you that at every step of the way, she was voluntarily going down this route, that she wanted this just as much as him. And yet, that's so fact, argument. You close, or you open up usually with like some law. Okay, and lastly, and I think someone asked about this. So let's say that we lose, we're now into sentencing. Huge deal, super gendered, right? If I got a pretty client, I'm like, you're gonna look how gorgeous, like I don't say this, but like, you're gonna look at this model citizen. She's going to school. She's getting her life on track. She's still young enough where, we can correct this. Like we can go forward, and we can get her the services she needs. We can get her like, taking her classes. She's got a plan. Let's go. Judge, my judge, like, okay, yeah, sure. Like he'll give better conditions. Um, and then if we go down another route, there's things called specialty courts. Sound great. Specialty court, don't go to jail, do this rehab, do this whatever. You're on probation, you check in with the judge, you learn some lessons, you go to counseling, they get you treatment, they get you set up with Medicare. Sounds great. Is awful. Is god awful. And I don't know, I think someone said restorative justice, whatever, but specialty courts are horrifying because a lot of people, not too much staff, federal funding, okay, whatever. But you have probation officers who just, and judges who just don't, they're not defense attorneys. They're not there to understand and empathize. They're there to keep people on track with whatever arbitrary system they've imposed and in line with whatever morals they hold. And they just shove them through a program, whatever it is, rehab or domestic violence classes, or like we have one here that's like Native related. And they just fucking like, they just ruin people's lives. Like probation officers just like, they get offended easily. They're arbitrary. They are humans, and they just get like, I mean, there's a whole bunch of programs here where it's just like female Native Americans do worse, just flat out do worse here. Male, lighter skinned people who identify as Native do better. And then it's our job as public defenders to make sure the system's held accountable, that we keep things equal. And we're in those courts to make sure rights aren't violated. But that's where you go. And then, you know, that's specialty court, that's after sentencing, and that's in probation. And then probation, again, like I said with pretrial, it's all about probation officers, their own inherent biases, like the problems we see. And it was always gender, class, like they just, like one judge told us that this meth addict should stop doing meth and go to a spa. Like, and then I shit you not, one judge who was dealing with Native American population suggested going to like Catholic school or to go to church more often. And if no one knows about the history of abducting Native children and making them Catholic in like concentration camp-esque boarding schools, like that's a horrifying, like to even get close to the mere suggestion is such a betrayal of history and the lessons we have learned. Anyway, I'm sure my time is up and I'll take questions, but like that's kind of like the life cycle of a case. And then we can talk about like what gets somebody revoked and just put in jail for their max. But yeah, I hope I touched on enough gender stuff, but that's kind of the realm, and I would love questions and love to talk about stuff. I'll look at some while we get going here.
Okay, so thank you so much, Sam. This has been really fascinating. There are quite a number of questions, and we only have 5 minutes of question and answer left. What I plan on doing is we will stop the official talk at 1, and if you want to stick around and answer people's questions that come up for people that can stay, that would be great. Does that work for you?
Oh yeah, I'm fine. Yeah, I would love to keep talking.
Okay, so in the last couple of minutes then, before I stop the official feed, there's a couple questions in the quick Q&A forum that I'd like you to see if you can take a shot at. And the first one's from Paula, and she asked, is it hard to balance strictly following your job and the law when your beliefs, morals get in the way? Is there any instance where this has been in doubt?
No, I mean, obviously a little bit in doubt because I'm here talking with you all. But usually I'm pretty good, and I don't know if it's better or worse, but there's usually pretty good of reconciling the two, at least to some degree. Like I said, usually telling a sort of, I used to call them survivors when I was in women and gender studies, and now I call them alleged victims. So that's a whole thing. But usually when I tell an alleged victim or survivor that they are lying, and then I make an argument trying to prove that they are lying, that's usually the hardest. However, I typically only are put in that situation when I have a damn good reason to believe so. Um, Someone asked about pleading. If there's a good plea offer on the table and for whatever reason they want to take it, that's something we do quite often. On most cases, plea out or resolve in different ways. But as far as reconciling it, there's only usually I have a good. Usually I can in some way, either by knowing my client, empathizing with them, holding the state to a higher standard, or just the need to win, and kind of fluctuating between those three are the probably biggest. Yeah.
So how does all of this change when your clients are transgender?
Oh, thank you so much for this question. Okay. Yeah. Well, one, man, maybe I should have started out with my pronoun usage, but one, usually if I have a transgender client, I just want to go to bat harder for them. Maybe that's fucked up to say, but I want to go to bat harder for them because I know that they're going to face an uphill struggle for their lives, and the criminal justice system is brutal to people who are transgender. So the last transgender client I had, and we got all the cases dropped because we had video of cops taking our client into a cell to beat the fuck out of her. Sorry. Sorry, I say him because obviously all the court settings, and they never acknowledged her pronouns. And so yeah, we got all the cases dismissed because we found a lapel video where the cops had forgotten to take off the lapel video, and one cop stopped 4 other cops from coming into the cell and said, "Oh, I got this." The other cops turned around, and before they could mute their mics, one cop, like one female officer, chortled, "Oh, he's gonna beat the fuck out of him." And they all laughed and walked away. And so all of my clients' cases got dropped because we brought it to the press. Obviously, no one really gave any crap, but Albuquerque Police Department dropped the cases. So
Excellent. So I would like to, because most of the people in here are students and are, some of them are interested in this career. Can you give us your last comments for today? Give us a couple of hints on how you get into doing a job like you're doing.
yeah, that's the hard part. There's no real traditional way to get here. For public defense, it's a really hard, well, not hard, but it's a hard place to get into because you need to have like a serious passion for this. Like I said, they're testing your passion and resolve and fighting these cases. So, I mean, I came from women and gender studies, and that's supposed to be directly opposite, but I was able to show my potential hires and people around me that, like, actually it's useful. I can understand these oppressions. I can understand my clients. I can understand my coworkers better. And that's kind of how I got into it. But basically, you just have to show what you're passionate about the most is applicable to this kind of work, or whatever legal career you go into. But especially with public defense, it's passion driven, and you have to show people that, like, come the hard times, you are here for something bigger than yourself, and that will keep you going in the worst of spots. So that's kind of how I would think. I don't know if that helps too much, but
Excellent. Well, thank you. That to the minute of our time. So this is the end of the official part of the talk for this week. Next week, we're going to have Joy Aodell, who's going to talk to us about organizing youth in Sonoma County for the Black Lives Matters events that happened all summer and continue to happen. And that's going to be a fascinating talk. Give me a moment. I know we can't really hear the applause, but let's all give applause to Sam, and thank you. I know it's weird speaking to a bunch of names in the void, but I really appreciate the work you do, and thank you so much for talking with us today. So I'm going to leave the channel open a little bit, and we can address a couple more questions. People can even speak live if they would like to. Just raise your hand, and then we will go until that's done. All right, thank you, everybody. And then let's see if getting lots of thank yous here in the chat. It's really great.
thank you, everybody. I'm happy to do this. It was fun.
Great.